right, good afternoon, everyone. My name is Nikki Borchardt Campbell, and I'm the Executive Director of NAICJA. And thank you for joining our webinar this afternoon. So NAICJA has been doing weekly webinars on administering justice in tribal courts during the COVID-19 pandemic. So this is a part of our rapid response webinar series. And this week's topic is going to focus on criminal proceedings and provide two comparative examples within Indian country about how courts and how others are managing their criminal dockets in light of COVID and in light of court closures, restricted court access, and increased use of telephonic and video conferencing to oversee those hearings. Just as a brief introduction to the whole system. Hopefully many of you guys are just rejoining us, and if you are, thank you for joining us again. If you're new, feel free to go ahead and explore the toolbar on Zoom. So you should have access to a chat button, and go ahead and click that button, and there's going to be a chat box that pops out to the right of your screen. Keep that open. Feel free to introduce yourself and tell us where you're joining from. Tell us how you're doing, most importantly. And then also, if you have any questions along the way, we want to make sure that you're interacting not only with our presenters, but with each other. So feel free to ask and answer questions here in the chat box. There's also going to be a second option for you to ask your questions to the presenters and to any of the staff on the panel, and that's to click on the Q&A button. So feel free to click on that Q&A button as well, and that will provide you access and the ability to ask questions directly to the presenter. The staff and I will be monitoring both the chat box and the Q&A box. So make sure that you are asking any questions. We will have some formal time at the end for a facilitated discussion and Q&A, but we definitely recognize that as our presenters are speaking, that things will pop up, and we welcome you to make sure that you are getting those questions asked, and that we should be able to have time to answer them either during the presentation or during that facilitated Q&A. As far as the housekeeping goes, the last thing is that if you click on the participants, you should have the option to raise your hand as well. So if there's something urgent, or if you'd really like our attention, feel free to raise your hand, and we'll keep our eye on that as well. And then lastly, if there are any polls, there will be the option to have polls and to answer your polls here as well. That being said, again, I'm Nikki Borchardt Campbell. I'm the Executive Director, and I'm going to help facilitate the discussion for this particular presentation. We will shortly introduce you to both Judge Whitener and Judge Fred Urbina as well, our primary presenters. And then, first of all, I would love to be able to introduce our president of NAICJA, Richard Blake, and to allow him to provide a brief introduction of NAICJA, and then we'll go ahead and move into our presentations. So again, this is Richard Blake. He's the president of NAICJA. He's the former chief judge at the Hoopa Reservation, and he sits on several benches right now. So thank you so much for joining us, Richard.
Oh, good afternoon, everybody, and thanks to the presenters today for presenting on an issue that is been requested across Indian country as we face this pandemic in this nation. Again, I wanted to first start this by thanking the NAICJA staff, Casey families, National Council for all the hard work that they have done. As we are holed in, please understand, forgive my informalness. I'm sitting on my front porch today because of my present court to the Redding Rancheria is 2.5 hours away, and if I go to that county, I can't come back here for 2 weeks. So I'm stuck here on my porch, and I certainly hope that this finds everybody well, and that you enjoy these presentations as we fold them out to you. Again, thank you for participating, and welcome.
Great, thank you, Judge Blake. And I'd like to introduce you again to our presenters. First, we have Judge Fred Urbina. I'll allow him to go ahead and introduce himself as well. But he is the Chief Judge at Pasquayaki, and we're very honored to have Judge Urbina join us today to talk to us a little bit about his courts, his operations, and what they're doing at Pasquayaki in light of COVID. And then we'll have Judge Ron Whitener address us on some practices, some general practices as well in Washington County, not Washington County, Washington State, and what's happening with our tribal courts in the Northwest. Ron is a former board of director for NAICJA, and we are very pleased to have both of our presenters join us today. So thank you. With that being said, I'm going to go ahead and turn this over to Fred.
Good afternoon, everyone. My name is Fred Urbina. I'm an associate judge at Pasquayaki Tribal Court. I am fairly new as a judge at this court, but I've been working for the tribe for many years. And so what I'll be talking about today is a few of our practices that we've implemented since COVID-19 regarding our criminal matters. And really, I guess we started to look at these issues prior to COVID-19 because we had a cyber attack at the court that forced us to start to think about continuity of court operations, which NAICJA had a webinar, I believe, a week or two ago regarding how you would operate a court system when you were down, either from an electronic issue or like we're experiencing now, something like a disaster. These are some of the things that have happened at our court. And you can go forward. And so for the Pasquayaki tribe, just like any other tribe across the country, across the continent, for us, the impact of disease since 1533, since the arrival of colonizers to our homeland has been devastating for the Pasquayaki people. We've had, just like every other tribe, experienced, the COVID is just not new for us. It's devastated whole peoples across the country, and it's not anything new that we are experiencing. It's something that we have over the years, over the hundreds of years, have addressed from a tribal perspective. So you can go on there. That's a map of where we're located. We're in Arizona, southern Arizona, what is now called southern Arizona. Just southwest of Tucson is where our court is located. We're located on a small reservation southwest of Tucson. There's about 5,000 inhabitants on the reservation, and we have about 22,000 enrolled members who mostly live in Arizona, either the metropolitan Tucson area or the Phoenix area primarily, with folks spread out across the country. Recently with COVID-19, we have had a few of our tribal members contract COVID-19. I believe it's primarily because of our location in southern Arizona. We're located just outside the metropolitan area of Tucson, and most of our tribal members live in the Tucson area, and that's where some of our traditional communities are located. And so there's a lot of movement back and forth into the county proper and also into the city of Tucson. We've taken measures that I'll talk about here in a minute, but it's just like the Navajo Nation, just like other Arizona tribes, we're all dealing with this, and it's impacted us here personally with our families. We don't have as many cases as percentage-wise as the Navajo Nation or other tribes, but it has impacted some of our families. And you can go on to the next slide. This is our court. This is one of our courtrooms. It's a fairly large courtroom. We operate A tribal court system, we operate our own detention services. We have a small detention facility that's attached to the court. It's about a 24-bed facility. We have our own probation department and our own pretrial services department, which is helping us currently dealing with this crisis. We have 3 courtrooms that are operational that we've been using through this crisis by our court staff and our court team. Right now we're physically separated into teams, and we're using different courtrooms during COVID-19. But our detention services is provided by the Bureau of Indian Affairs. So we contract with the BIA for any long-term detention. Our detention services on reservation is conducted by our law enforcement department. They are a tribal law enforcement department with about probably 15 detention staff members who are tribal detention folks. Any long-term detention or people that are held awaiting trial are taken off reservation to a BIA contracted facility. Next slide, please. What we're trying to do and attempt to do on the reservation is, like everybody else, we're trying to flatten the curve without taking drastic measures, protective measures on the reservation by our executive and by the court. There's a possibility that we can have an impact on the cases on reservation, meaning we would be responsible for increasing the number of cases versus reducing the cases and keeping it as low as possible on the reservation. So we do that by our protective measures that we put in place, and also using things like PPE within the system. I'll talk a little bit about that, but essentially we're trying to flatten the curve on the reservation, working with county officials and state officials while doing that through our emergency management system. Here, this is basically, I think the tribe started to see things happen up north. I think Umatilla, started to see some of this happen up in northwest area in Portland. So we saw that the Umatilla casino close. We started having conversations about this, and the tribe started to actually do a couple of things in preparation as things kind of got out of control. Our health department kicked in with our executive team, our chairman. The chief judge issued an order on March 12th announcing courthouse restriction, closing it essentially to the public, just like a lot of other courts have done. We've shared our administrative orders with NAICJA and with other courts as we develop this process, and we've been working in conjunction with our health department. Next slide. So this is the timeline continues into March. The tribal chairman issued executive orders. The court issued a general order basically giving law enforcement, the community guidance, and the court guidance, court litigants in civil matters and criminal matters regarding all trials and anything scheduled at the court, basically pushing everything out to mid-May. That was part of the court's general order that the chief judge issued. And it's similar to other administrative orders issued by tribes like Tulalip and other tribes, basically pushing everything out that we could, and really reserving any kind of court matters to emergency issues and in custody issues. Everything else is going telephonic, or we're also using GoToMeeting. And that's the guidance initially ordered in March. Next slide. So the court also started to implement procedures within the court. This happened as we sent out the general orders. We restricted access to the court to one point of entry. That's walled off with glass. And so there's no contact. So all court transactions is happening out of one area. We've separated the court staff into teams, and also separated the court areas into teams to include bathrooms and common areas. Calendar-wise, we're coming in on different days, and the court has reduced its hours during this crisis. So these are steps that we've taken internally, procedurally, to address this issue. We're not letting anybody in unless they're screened. Even in custody inmates have their temperature taken prior to entering the court. If their temperature is over a certain, if they're running a temperature, they're not allowed in. If they're arrested, they have they actually go through a medical screening by our health department. And if they're coming from a BI facility, they also have a medical screening as they come back for any additional hearings that they're going to have. So a lot of things have been put in place for us to manage internally. We are also using PPE, masks, and social distancing within the courtroom. Next slide. Some of the guidance that we gave to law enforcement is that, and this was contained in the court's general order, is that we would be looking at things like warrants and high-level matters, domestic violence, cases with victims, things like low-level warrants. We were asking them to hold off on executing warrants. We're asking them to cite and release in matters where they can. We're pushing citation timeframes out for 45 days. And we're also doing these public health screenings and procedures as people come to the court. I call it a new pandemic because it's a pandemic that we're dealing with today, but it's not anything new to our tribe. Some of the things that we're doing within the court started off with external guidance from our tribal council, our health officials, our internal control measures. We went on to the health screening that I talked about, the security restrictions, PPE and social distancing within the courtroom, also detention options. We're fairly active court. So I was in court yesterday. I had 4 hearings for people that were either in custody or we had cases with victims. However, because we have a pretrial services department, most of the people that come who are arrested and held, they're being placed into pretrial services after the initial hearing. So right now we have about 55 people who are being monitored by pretrial services on the reservation or off reservation, with about 8 to 10 who are on ankle monitors and restricted to their house or being kept away from victims in their cases. The court scheduling has changed also, so any subsequent hearings are being pushed out. The litigants are working together to submit motions either by the defense or by the prosecutors. Most of the motions are uncontested. They're cooperating. You know, we're looking at constitutional issues, due process, but the parties are working together. The defense counsel have been mainly concerned about their clients being held in detention. If they're not in detention, then they're actually motioning for these cases to be pushed out for compassionate reasons, for everybody's being flexible. And really the main purpose is to protect the staff, protect the public, and protect the rights of the people in custody and protecting their health as well while they're in detention or while they're in the custody of the court system. Pretrial services is a program that's been running for about, I want to say 10 years. And they're I would say a large majority. We used to have on average probably close to 80 to 100 people in detention on any given day. Since pretrial started, it's down to a handful of people who are held pretrial. Pretrial services takes people and monitors them while they're released in the community. These folks generally aren't paying bonds, but they're being monitored. They have to check in. They're doing that electronically or by telephone, and they're using GPS while they're monitoring people in the community. This has helped us shift people out of detention back into the community while making sure that the community is safe. We've had a rise in domestic violence cases, drug cases, and mental health cases, cases that involve someone who's either SMI or dealing with mental health issues in conjunction with either alcohol or drugs. So we've seen a rise in those cases in the past month or so. It's gotten pretty intense with these types of cases. So we're still seeing people in court because of the level of sometimes the level of violence and what's happening in the community. Next slide. So our Constitution doesn't say much about how the court operates when there's an incapacitating event. We did have, the whole tribe was basically subject to a cyber attack. Our whole system went down, and the Constitution doesn't address when this happens. The court has to continue to operate. The court's general order is consistent with our Constitution and the Pasquayaki Bill of Rights. The Constitution is basically it's based off of BIA template, so it's a lot like the Constitutions. A lot of them you see out there, but it has the ICRA basically built in as the Pasquayaki Bill of Rights. And so we're considering things like speedy trial, cruel and unusual punishment, equal protection, due process. We haven't had any writs yet, but we've had some motions and some discussions about whether or not someone's going to stay in custody. We just dealt with that yesterday as well in another matter where the defense counsel was basically not agreeing to a motion to continue. And so we went on record and we basically went over this. Folks made their arguments and we made a decision that day regarding this issue. But we have a pretty robust public defender's office and a pretty active prosecutor's office. So we're seeing these motions come forward. We're addressing them by trying to balance the public health issue with due process requirements in these criminal cases. Also citing the court's general orders, what's going on nationally, what's going on within the state, and the executive orders by the council. Next slide, please. This is what it looks like in our courtroom. This is one of our cameras. That's me on the bench and my clerk. We basically bring people in. Everybody's got PPE on. The defendant's sitting in the jury box generally, and the public defender and prosecutor are separated pretty good distance. Our bailiff also is wearing PPE. The court's cleaned prior to use and cleaned after use, wiped down and everything. And then also we're screening people as they come in, either with the screening form, but also temperature, we're screening them as they come in. The litigants that come into the courtroom, they're either on the telephone, the public defenders, or if they come in, they're also broken up into teams. So if one of us gets sick and we've been exposed to the rest of the team, then that team will probably go into quarantine. The other team will take over after that happens. And so all the other departments are also broken up into teams to facilitate this. Next slide. When we talk about the potential for transmission by one of the court staff, This is just an illustration of what could happen from our pretrial department or our probation department or one of our staff members if they were to have contact with their clients or the people they work with. We could quickly spread COVID-19 within the community, within our fellow staff members, and people that we're monitoring either pretrial or after our criminal matters. COVID-19 considerations in the court, I kind of went through a lot of this. We're releasing a lot of people from custody. We're kind of looking at service of process, doing things by certified mail, looking at phone contacts at the initial hearing. We're deeming notice given at the initial hearing because they're signing for notice at the initial hearing. We're looking at telephonic appearances, and we're actually having people appear telephonically. Some are asking for the waiver of the appearance of their client, which is the court has granted on 2 occasions already. Some emergency legislation that's happened on the reservation was emergency powers for the executive council, for the chairman. A public health code was put into place. The public health code is to support quarantines and things that happen within the reservation community. That quarantine and that actual public health code will be enforced by the health department, by law enforcement, and then also there's a court process for any kind of challenges to any kind of quarantines. So that has happened within the past month by tribal council. We're doing a lot of coordinating with the executive branch departments, outside agencies. We're looking at other ways of operating. We've already implemented that. I talked about telephone meeting and universal precautions. We have a hand washing station outside of the court complex. So when people come in, they could wash their hands before they come to the court. Next slide. And that's all I have. I just want to send a message and ask everybody to be safe. I know it's difficult. I know this is impacting everybody. It's kind of scary. It's getting hotter here in Arizona. It's about 104 today. It's the hottest it's ever been. So in April. So I just want to pass that message on to you. This is a local Native poet, and I wish everybody their safety and their health going forward. And thank you for everything you do in helping to keep your community safe.
Thank you so much, Fred, for that presentation. Another really excellent reason why, obviously besides, Fred's experience and his experience on the bench, but, what they're doing in maintaining court operations and looking at alternative modes of operation and the COOP planning. This is also going to be relevant for a lot of our tribal courts moving forward, especially for those who have either closed court operations or have severely restricted that type of access. So these are all questions and things that are going to be relevant to us as we're moving forward, especially those, the changes in your internal procedures, and in those internal controls and the screening. So thank you for that, Fred. We do have a few questions, and if you don't mind, we would love to be able to answer those at the end.
Okay.
All right, and here you have Judge Urbina's contact information right here. We'll make sure that everybody gets a copy of this presentation as well, so you can have all of the contact information and you can see the repeat of this video. So now we'd love to turn this over to Judge Ron Whitener. He's a retired chief judge at Tulalip Tribes. Ron, as we mentioned, was also a former NAICJA board of director, and he is quite experienced in not only working with tribal court assessments throughout Washington State and Alaska, but he's a seasoned judge and attorney. And so we are very honored to have Ron with us. So Ron, I'm going to go ahead and turn this over to you.
All right. Thanks, Nikki. Does seasoned mean old?
No.
All right. Well, thank you for having me. I had the sort of weird, I guess maybe fortune of deciding I was going to retire from the bench at Tulalip before all of this hit, but it hit before I actually retired. So it was something that we had to deal with early on in the process, and then sometime after that, we handed it over to Michelle Demert, who was the new chief judge at Tulalip. So I'm going to talk a little bit about what we did. Fred's presentation was amazing. Pascua has done a lot of the things that I think tribes need to consider going forward for their tribal courts. So I'm not going to spend a lot of time talking about the same things that Tulalip's doing, because a lot of it is similar. But I do want to talk a little bit about what we dealt with in the process of this hitting. So if we could advance the slide. So Washington's one of the, we were the first state really, I think we were the first state that had the first death from COVID-19. We had somebody from travel from Wuhan to the state of Washington who then got very ill, checked into the hospital, tested positive, but by that time, that person had spread it around a little bit, including into a nursing home in King County, where it spread very quickly. And we've, at this point, as of just a few days ago, we had a total confirmed cases in Washington state of 14,000 that we know of. One of the problems with COVID-19 is that there's a lot of people who don't develop symptoms. They catch it, but then for some reason they don't really develop anything that's alarming, but they're still, they can still infect people. So they walk around with it without having any knowledge that they have it, but people that they touch, it has a very high transmission rate because we have really no immunity to it because it's such a new virus. And so it spread very quickly around Washington, really starting in February. Can we go to the next slide? So at this point, as of April 28th, on that date, on April 28th, we had 15 deaths in Washington state. But you can see from this graph that we're well past our peak, which was really at the very beginning of the month. And we've been sort of going up and down, but a really nice, steady, gradual reduction down. But as you can see from where this started, basically back in February, things started ramping up. The Snohomish County, which is next door to King County, it very quickly jumped into Snohomish County. And it also very quickly jumped into the tribal population here in Washington state. Can we go to the next slide? So in the Portland area right now, we have approximately 124 cases that we know of through IHS and tribal facilities. This isn't the true number because this also doesn't take into account programs like urban programs or some tribal programs that don't report. So this is a really low number. This is probably a low number, but right now we think we have about 124 cases in the tribal system. So if we go forward again. It's hit the Western Washington pretty hard, Lummi especially. Lummi, this is from April 16th. From April 16th, they had a total of 21 positive cases at Lummi and had several deaths. Tulalip's had several cases, and they came early, and it really sort of was shaken home to Tulalip because one of our sort of a very well-established, well-known and respected elder became sick with it and then very quickly passed away. And that really sort of shook Tulalip, and Tulalip began moving pretty quickly to shut down both the tribal government and also all of the tribe's gaming facilities. And so we began working at Tulalip on what to do. And I've talked a lot, and I'm sure people have listened to a lot of the discussions of the administrative orders and what we do on those, but I'm not going to go into too depth on that. We did about in the middle of sort of the second week of March, we issued administrative orders, at that point pushing everything until April 1, because at that point we didn't know much still, and we weren't sure of how long this was going to last. And so we just took it to the end of that time. We just went through every one of our criminal types and looked at what we had to do, what we could push, everything that was civil, that was more voluntary, things like child custody or dissolutions or things like that. We pushed those, sort of continued them indefinitely. And then once we start opening up at Tulalip, they will start taking those cases and start processing those again. We dealt with the criminal cases a little differently, sort of staggering those. And I'm going to talk a little bit more about what we did to deal with those cases. We addressed youth in need of care and created procedures for youth in need of care cases, domestic violence protection orders. And we really tried, and we did the main administrative order, then we did supplemental orders, and then Judge Demert has done new orders as it became clear that this was going to last a lot longer. And then when the tribe reached the point where it had to start furloughing most of the people in the tribal government, frankly, she then had to adjust again to deal with the reduction of staff. The tribe went down from having 5 judges, not all full-time, but they furloughed most of that and took 2 judges that they kept on to create 1 FTE, split the week, sort of similar to what Fred had talked about in developing teams, having the court available to do emergency issues, but to really reduce the number of people that can be in the courtroom at any one time. And then the court pushed out information to the membership through its website on what the process was for their types of cases. Can we go to the next slide? And so on the website, the tribe has, for each type of sort of things related to the types of cases, information for who you call if you need support or discussions about it, along with the court clerk staff email so people can e-file and deal with their cases. The cases that are non-emergent, those are all have been pushed. Of course, you know, differences of opinion are out there in terms of what's important and what's not. And so the tribe did create a way for, if someone, for instance, in a family law case, felt that they had an emergent issue, they could essentially petition to have that heard by the court. It goes up to the chief judge and the court director, who looks at it, and then the chief judge essentially makes a decision on whether or not it's an emergency or not. If it is an emergency, then they'll pull together a hearing over GoToMeeting and hold the hearing. If it's not emergent, then the person will be informed officially that it was deemed non-emergent and pushed and would be rescheduled later. Go to the next slide. So again, the website goes down through the various types with a little bit of explanation for everybody on what's happening. Everything's being conducted. At this point, it's being conducted over GoToMeeting. The arrests and things are still occurring. The hearings post-arrest and other things have been pushed. Go ahead to the next slide. So really, when we looked at it, this is sort of the way that we thought about it from the criminal part. And I'm really just addressing the criminal at this time. And I'm also going to address it a little bit from the point of view of a defender, because you know, that's my background. Prior to being a tribal court judge, I was a tribal public defender for a long time. And so a lot of these things that I've done has been in the thinking about it in terms of how you provide public defense in this stage. But really, we looked at the types of people that we had to deal with in the criminal system. The first being pre-charging suspects, so somebody who commits a crime but hasn't been charged yet, hasn't been arrested yet. The pretrial defendants, those people that were in the system already, that had been arraigned and had their speedy trial clock already ticking, heading toward a trial date. And then those people that were in some sort of post-disposition circumstance, either they'd already been pled guilty, they've already pled guilty and had been put into probation, or they had entered into some sort of diversion and oversight like the wellness court. But they no longer had a speedy clock sort of ticking on their case. So those were the 3 main areas that we dealt with. Can we go to the next slide? So in the pre-charting strategy, so you've got somebody who commits an offense. The tribal police department has been given a little bit of discretion as to what they want to do. You know, they could just admonish somebody, essentially tell them, well, you're really lucky that we're in the middle of this, because normally I would, you know, send this to the prosecutor, but, you know, I'm just going to keep my eye on you, and I'm going to hang on to it. And if you commit anything else, I'm going to send both the new thing and the old thing to the prosecutor. So they are using a little bit of in the field pressure with people, trying to encourage them to not commit crimes, but still kind of having it in their pocket if they need to. Or they can investigate a crime and then just refer it to the prosecutor for later charging. So the prosecution can look at it and sort of make the decision, is this something that we're just going to hang on to, or something that we're going to kickstart the case now? That most of everything, if they weren't arrested, probably can be pushed quite a ways, and you don't have to start the speedy clock. The other thing that what I see as a difference between Indian country and the state is, in Indian country, and I'm sure there's exceptions to this, but in the jurisdictions that I've been, things happen pretty quickly. Somebody does something, they're either arrested or they're cited, it goes to the prosecution pretty quickly moves to some sort of summons or hearing, and they take off. But if you look at the states often take a lot more time. Somebody that a tribe would arrest, they may arrest and then kick, not start the speedy, you know, take them in for the bail hearing, release them, and then just sit on it and let the prosecution do its investigation. And when the prosecution has all of its ducks in a row, it's sent all the, you know, any drugs to the lab and has the lab report back, send any, you know, blood tests to the lab, and then they take their time sometimes. In Snohomish County, for instance, I mean, I'm not saying that this is a good practice, but even before COVID, there were a lot of state cases where someone was arrested, released by the court, but then wouldn't be officially charged for up to a year while the prosecution sort of churned through it and got to it. So you don't have to move as quickly as you might be normally used to. You can sit on some things, understanding that this is a special circumstance, and wait to initiate the speedy trial clock. And then you've got the arrest and PR. So that's the situation where they arrest, it gets in front of the judge. The judge doesn't want to start the speedy trial clock because they know that it'd be very difficult to get a jury. And so they release, and expecting that sometime down the road within the statute of limitations, that the person would be summoned in and the case would take off again when you could convene a jury. And then finally, the more serious ones, you know, are you going to arrest and then actually arraign somebody? Are you going to start that trial clock again, kick them, and then use a tolling of speedy, which has some risks later on of potentially being found to be inappropriate, and you could have a case dismissed should a court of appeals decide that it was unreasonable to let the speedy clock toll for that particular situation. Next slide. So then with pretrial detained, so these were people that we had already arraigned, we had a speedy clock ticking, and then this whole thing hit. And so we had to decide what we were going to do. And so the first thing we did was look at everybody that was in custody and said, well, can we release them? Can we let them go under some conditions? A lot of people we just let go with just the general conditions of don't do anything bad, just be good, go quarantine and be good. Some we released onto electronic home monitoring. Some we released onto a global positioning system bracelet so we could watch them. And so really we tried to get everybody out of jail that we could possibly release. For people who were in but had enough time in that the prosecution was comfortable that they'd gotten their time out of them, they pushed sort of ahead of time. Normally they might have waited a little longer, but they made an offer of a credit for time served plea, which essentially the defendant pleads to it and they get out of jail. We did those at first telephonically and now go to meeting. The defendants would be transported from the jail facility that Tulalip contracts with to the police department into their holding. they would appear from holding and not be transported to the courtroom. The courtroom would just have the clerk in it. The clerk would set up the recording system, start the hearing, and then everything else would be done telephonically or now over GoToMeeting. We would do the colloquies. One of the things that I did was I beefed up my colloquy, brought a little more questioning of the defendant, a little more questioning of defendant's counsel, just to make sure that I was comfortable that it was knowing involuntary, and that I felt that the person was competent to be able to do a plea at that time when I couldn't see their face. And we made sure that they had a private phone that they could discuss anything. If anything went sideways, they'd have the opportunity to discuss with their counsel that was off the record and confidential. And we went through those people that we could enter pleas for. And so we did those. And then the third was, there were very few of these, but there were a few people who the judges just decided, over the strenuous objection of the public defenders, but decided to continue to detain because their history was such that the judges just weren't convinced that they were at less risk outside than they were inside, just based on past compliance, ability to remain sober, and then also just taking into account that if they were released, they not only would be putting themselves at risk, but they would also be bouncing from house to house to house to house and possibly spreading something. And so there are just one or two people, I think, they made the decision to hang on to and not release from the jail. The problem with that is that the jail does charge more for people. They've been putting in more procedures and PPE, and then charging the tribe at a higher rate than they would normally. So it's more expensive for Tulalip to keep those people in jail. Then for pretrial undetained defendants, so people who weren't in jail, they'd been arraigned and they were out on conditions, we just good caused extended speedy, pushed out the jury trial, and those are just floating along until the tribe gets to the point where it thinks it can hold an actual jury. And they're discussing ways to do that. One of the things that's probably going to happen is that the courthouse at Tulalip is pretty large, but it would take a bit of work to be able to do the kind of social distancing that you would need to be able to convene a large enough jury pool to actually get through cause challenges and preemptory challenges, plus just the no-show rate in terms of people who just won't show up because they're afraid of getting sick. I don't know when Tulalip is going to be comfortable about that. We are at a stage in Washington where we are sort of discussing gradual returns to work under very strict circumstances. But the jury pooling problem and sequestering problem is a difficult problem. Some discussions have been about moving the large jury selection to tribal, arenas or basketball courts or places like that where you can really spread people around and keep them away from each other. But really the jury trial is the real problem. The other thing is, again, the prosecution just sort of wanted to get them dealt with. And so the prosecution would made some offers for pleas that the defendants just couldn't resist. And so they did do some cleaning up of cases that they thought they can plea. And then an option is you could always dismiss. It's not like, hopefully a pandemic doesn't come around every, year. So if you've got some people on minor charges, one of the things you could just do is just dismiss those charges. If you just got, some minor things, just let them go. So that's another thing you can do to kind of reduce the total number of people burdening the system. Next slide. So, there's also been a lot of discussions about speedy and this tolling. This is just a few of the things that, for instance, under the Federal Speedy Trial Act, speedy trial is, I put that in quotes because it's not that speedy. We usually have like 60 or 90, 60 if they're in custody, 90 if they're out of custody. That's a really common standard. But there's a ton of things that already toll speedy, especially in the state and in the federal system. delays from any pretrial motions. If a pretrial motion is filed, then the time it takes to deal with that motion tolls speedy. If the court wants to take time to consider a plea agreement, it can toll speedy. If witnesses are unavailable, it can toll speedy. If the case is complex, it can toll speedy. So speedy itself is already a little bit of a loose concept in the case law and under the statutes. Now, if you've got a hard statute, then you might want to consider doing what Tulalip did. Is the board of directors just passed a pandemic code which dealt with home quarantining and other things. But one of the things it did was that if the tribe did declare an emergency for a pandemic, that speedy trial rule of 60 or 90 gets suspended. So that's, you can deal with it statutorily as well. Next slide. So in terms of like thoughts about what you can do. Oh, and then I actually go back a slide if you can, Nikki. I didn't put this in there, but this is something that I have seen done. You can also, if you want to not worry about like the jury, the right to a jury is tied to the risk of incarceration. And you can sort of get away from that Indian Civil Rights Act requirement of a jury if the tribe is willing to waive any ability to incarcerate somebody for a particular crime. So you could file something. I've been in situations to where I wanted a jury and the tribe didn't want a jury, but it wasn't a situation where they really wanted the person to go to jail either. They just waived any ability to incarcerate as a sentence. If you lose that, you lose the jury right. The Indian Civil Rights Act is actually, frankly, more protective than the sort of standard under federal constitutional law. If you look at the actual constitutional law related to a right to a jury, it isn't automatic. If it's around, I think 6 months is what I remember. It's like if you have maximum jail sentences less than 6 months, it's arguable that under federal law you even need to have a jury. But the Indian Civil Rights Act binds the tribes, and it requires that jury of 6 for any criminal case. And so if you waive it, you could buy yourself a bench trial if you really, really want to, unless you really, really want to be able to put somebody in jail. And we can get into the philosophy of that. My experience has been that I'd like to use alternatives like more contempt types of things. If someone isn't doing what they're doing, I would actually bring them into the court and make them sit on our church pew benches for 4 hours without their phone. And they hated that. And frankly, most of our frequent flyers, if you gave them the option of going to jail for 24 hours or sitting on a church pew for 4 hours without a friend or a phone, they'll take going to jail every time. So there are some things that you can play with if you want to get creative that could reduce your requirement to have a jury. Okay, next slide. So for the defense, some of the things that I think are important to think about is, I think you should reserve your objections. I wouldn't bet on winning, but go ahead and just, make your objection as to the speedy trial waiver, the push of the tolling of the speedy trial, so it's on the record. Then the Court of Appeals will make the decision later. I'm not going to bet on winning. Every court in the United States is doing this. Practically every court in the world is doing this. You can't. It's unlikely that this circumstance, coupled with the loose standards constitutionally for the speedy trial right anyway, putting those two together, I'm not going to bet any money that I would win on appeal a case unless I had somebody who was pretrial in jail and the jury trial got stretched out a long time. Then, I might maybe win that. Probably not, but I might. But go ahead and reserve the objections. Remember that protecting yourself is protecting your client. There's been some sort of discussions where public defenders are like, I need to be there in the room with my client, which I think is a little bit selfish, because one thing is that, it's very noble to not worry about being infected from the client, but you could also infect the client. And then your client could take that infection into a jail and spread it to a lot of people. And you need to keep that in mind. So it's important to work with the tribe on using the technology to represent your client. Take more time, because when you're not in person and talking, it's harder to know if your client is really understanding if you can't see them. You can't tell when they're wandering off and looking at their phone. So take more time, question them about what you've talked to them about to make sure they understand. And so you're comfortable that they know and are comfortable with whatever decisions you got, both the attorney and the client's making, and get to know the technology. This is going to be, I think, the new normal for a while. And then it also is something that will probably likely extend out a while as tribes realize that you can use technology and don't have to pool everybody up in the same room all the time. It could very well be that what we're going to see out of this is courts using more distance technology to be able to hold hearings to make it more convenient for really everybody. So I think that's important. Next slide. So one of the things that I wanted to put in here was the UW Tribal Court Public Defense Clinic, which is the primary public defender at Tulalip, has actually done a lot with distance public defense. We've had projects where we've provided distance defense for tribal defendants who are in systems where, but for what we could do remotely, they would have no representation, especially with juveniles. We had we had some courts that they just weren't, and they didn't have funding to be able to pay somebody to drive all the way out. And so we did a lot of work with this back probably starting 10 years ago. So the clinic has been doing a lot of remote work for a while. So they are a resource for tribes who are looking at trying to figure out how can we provide some legal representation to tribal clients when it all has to be done remotely. So if you do want to talk about how to do that, or if a tribe is interested in having the public defense clinic do that for you, you can get a hold of Brenda Williams at that email and that phone number. Next slide. So that's it. Those are my thoughts. I'm happy to answer any questions.
Thank you, Ron. We do have a couple of questions that have popped up in the Q&A. I know that we've been able to answer a few of them live, but the one that I'm always interested in hearing both from you and Fred and other judges is how are you guys facilitating the interactions with pro se clients and unrepresented individuals in your courts?
You want to take that, Fred? Do you want me? Well, what we've done is we've tried to provide as much information on the website. Tulalip put everything on the web with phone numbers and emails for people to call. Some of the things that they've done for helping that are, for instance, let's take the youth in need of care, or what Tulalip's child welfare case. When they're doing petitions and they're serving things on people, they've put in the instructions for how to get on to GoToMeeting in what's served on people. In notice of hearings, they're putting it in the notice of hearing so that people can see the instructions on how to do it. Tulalip also is fortunate to have the Tulalip Office of Civil Legal Aid. So things are kind of funneled through them. They screen people who, for instance, if you have a domestic violence protection order petition that you want to file, they'll look it over, help them with it, make sure they have every bit of information you need in one of those so it doesn't get kicked back from the judge, and then facilitates filing it. So those situations are helpful. Those are things that Indian Legal Services could certainly help with around the country for people to be able to consult with them, help them make sure that their pro se petitions and everything are all done, so you don't end up giving it to the judge and having the judge kick it back a few times before the judge has everything they need. But it's a lot of getting out the information, putting the things on the doors of the courthouse. So if people are coming to the courthouse, you know, it tells them what to do, who to call, how to get a hold of the clerk. You know, at Tulalip, they've kept one court security officer at the front door. And so if somebody comes in asking for something, that the security officer can provide them self-help materials, give them the packets. If you don't have the packets, create the packets, I guess. Things like that. So people can do as much as they can on their own without having to have somebody help them or having a judge sort of guide them through it, because the judges just are not going to be as accessible right now as they were.
And at Yaqui, we're if criminal folks are facing any kind of jail time, we'll appoint a public defender on their behalf. However, if they waive or they're facing no jail time, they are pro se. The prosecutor is pretty good about touching base with them either before the hearing, at their home, after the hearing, having conversations with them. That'll also be facilitated by the bench, advising them that they can seek assistance, pointing them to a list of advocates and people that they could either hire if they wish to hire someone. There are some folks that do pick up tribal cases. The people that are generally waiving their right to an attorney, they're usually frequent flyers. They know what they want out of the process. Sometimes they feel like their rights might keep them in jail longer, so they're willing to talk to the prosecutor after waiving to see what they can talk about. So that happens by the prosecutor essentially talking to folks, but most, probably 99% of people are represented in our court.
Thank you, Fred. I'd really like to be able to go back to the topic of jury trials. And I know that, you know, we've had these discussions privately, and in former webinars, we've really talked about, you know, the speedy issue and how some of our judges and those who are detained are running against, you know, that particular deadline. Judge Whitener, you had mentioned and talked about the various possibilities for moving forward in order to conduct those jury trials in the future. So my question is for both of you again, but Ron and Fred, you know, how do you foresee us moving forward in light of COVID, in light of social distancing, and in light of all the new internal controls that a lot of our courts have started to implement as far as, you know, health screening and really not only trying to protect, you know, our court staff and our court judges, but our population and those individuals coming to, you know, participate in voir dire?
Well, it's tough. I don't know, because it's really going to depend on a lot of factors, like how soon we'll have a vaccine and, you know, how comfortable people are going to be. At what point do people feel safe to show up? Are you going to hold somebody in contempt for failing to appear for a jury trial? Politically, I don't want to be in that position. That would be rough. So that's a question I just don't know the answer to. I mean, I thought about it a lot. One of the things that I was kicking around is you could have, similar to what Tulalip did, is you could have a pandemic, sort of a pandemic code that sort of suspends all jury trials, but also suspends the inability to incarcerate somebody on a jail sentence if they went to trial. So it would force everything into a bench trial, and then have a specific crime that's sort of like, you know, failure to comply with your court orders on a case that went through that pandemic system. You see what I mean? So somebody gets charged with an assault. The jury trial or the right to incarcerate is waived. You have a bench trial. They're convicted. They go on probation. They violate the conditions of probation, and then you still don't have the ability to incarcerate them. You can't do it that way. You can't like not waive you can't waive incarceration hold a bench trial and then give them a jail sentence for violation of the probation, right? That waiver goes all the way through the whole case. But in theory, you could have another charge similar to like a criminal contempt charge that essentially charges them with a crime of contempt of a pandemic judgment or conviction, and then have the maximum for that criminal contempt match the original charge. So if it was an assault charge with a maximum of 6 months, then the criminal contempt for violating pandemic judgment would have a maximum of 6 months. See? So I don't know. I've been playing it around with my head on how you sort of manage law and justice if you can't convene the jury trial in a criminal case. I think we're going to have to either just let it go, just know that we're not going to be able to hold a jury trial for something between 6 months and a year, or you're going to have to go to extremes to try to hold it under some sort of social distancing system. But you have to know that there's a good risk that you won't have jurors show up. So then you'll end up getting the case dismissed for failure to convene a jury, right? It's a bit of a catch-22 right now. And there's no good answer.
Yeah. Any thoughts, Fred?
Yeah, I think you could, going forward, at least probably within the next year or so, I think, and this would kind of go hand in hand with how much resources a tribe would have. For us, we could probably do voir dire in a large auditorium. I'm thinking also of an expanded juror questionnaire to weed out potential folks who have other comorbidities and things like that. So you additional, almost a health screening portion of the juror questionnaire so that you can look at that as well. Also, as testing expands, I know testing has been a big issue across the country, but I know some tribes have some access to testing and are doing their own contact tracing. Navajo Nation, one of them. And so you can actually, you could probably ask if people have been tested, if they've tested positive or negative, if they've had an antibody test. I think in the future, we're going to get to a place where testing will become either widespread in some places, depending on your population and where they live, or perhaps you'll be able to do that for some things. And I'm thinking about the timeframes of a jury process and how you can actually extend as part of your sending these summonses out. You can extend that to allow for this additional screening and testing. So I think at least within the next year, you could probably things that are scheduled, you can start to look at these options to make people feel comfortable about sitting on a jury, being in a situation where there's social distance within a courtroom, and you're able to proceed to a 1 or 2 day jury trial where people are comfortable making a decision and administering justice for a court system. And maybe that's not going to be possible in a lot of places, but I think some tribes will have the resources to do some of that.
Yeah, absolutely. Fred, since you are allowing access into your courtrooms right now, and we did see that picture of you all with your PPE on, are you currently asking the individuals that you're screening who are coming into the courts those same types of questions, like have you been exposed, have you tested positive, have you been quarantined or in isolation, just to try to mitigate that type of exposure? We did see that the graph, one person exposed can potentially affect, a large subset and population of people. So is that something you're asking?
Yeah, it's we have a screening form. We also are checking temperatures of both the litigants and also the people who are in custody coming in from a detention center. We're doing that in conjunction with executive branch departments, but also at the court doors as well. And then also with our internal staff, we're doing checks internally as well. So that's happening internally and externally as people come into the courtroom. So we're not allowing the public into the courtroom, but people with business there, if they're not going to appear telephonically and they're in the courtroom, then they're going through this screening process.
Thanks, Fred. And I recently had to take one of my children into Children's Hospital clinics for a follow-up. And when they were asking those screening questions, they were actually asking like medical symptoms as well. So are your screening questions, or is that screening document include things like symptoms? Like, do you have coughed? Have you been sneezing today? You know, have you experienced, you know, these basic symptoms? Do those include medical questions?
They don't. I can foresee them, and that's for people coming in through the courtroom. That public health screening is done by health officials of people in custody. So criminal people in custody, they're getting that public health screening. We had a person who was in custody for their initial hearing. Their temperature, they had a temperature, and we basically did not allow them in the courtroom for one of the people that were coming in who had just recently been arrested and they were showing up for the initial hearing. And so there has been time, or we've had a court staff member who was also out after being sick. That person was quarantined and needed a doctor's note and was tested before coming back to work. So a period of 14 days for staff members who have symptoms, quarantined, plus any kind of testing that has to be done before they come back to work to expose either staff or the public or people that are in custody.
Okay. Amy Shabus has just a few follow-up questions as well, and I think you answered it a little bit, but she said, however, what are you implementing if they answer yes and get turned away? Are they re-noticed, or do they go to the hearing via phone? And if they don't have a cell phone, you know, what do you do in that instance? So are these rules implemented, or in the case of Plan B, in case of, you know, somebody doesn't pass screening and they can't conduct their business with the court?
I guess they're not hard and fast in that, you know, their hearing isn't going to get canceled. It will probably be continued. We'll look at alternative methods of having that hearing, whether telephonic or go-to meeting, whether they're represented or they're pro se. We're still conducting court business, like, you know, picking up their payments or making payments, checking in with probation. That's being done through a window and by the phone. So they're calling, they're showing up, they're doing check-ins. That all those things happen without any contact, any person-to-person contact. But it's one central point outside of the courtroom where people are coming to the court to conduct any kind of business. That's filing of a protection order, and also picking up their child support payments, things like that. Those things are still happening.
You bring up another really good topic that I'd love to ask both of you. In a few of our past webinars, especially when we're talking about moving things telephonically or to virtual hearings, or even issues related to closed courts and filing, making new filings through e-filings. My question is, what are your options either in your court, Fred, or what you've seen at any of the courts you've been working with, Ron, about accepting payments electronically through, you know, online, some types of apps? Are you doing it? And if you are, what website or what software are you using? Or if you aren't, you know, what are the impediments to allowing you to, you know, accept e-payments? We know that we have courts who have been doing a lot of virtual, but that's really one of the questions that we're trying to find some answers to.
So at our court, we haven't implemented an online payment system yet. We We have the ability for people to pay with credit card at the court window, but we don't have an online payment system just yet. I don't know if Ron does.
Yeah, there are systems that allow you to do that. I was just talking to Kalispell. Kalispell has a system that you can pay your fines and infractions and things over the website. The company takes 6%.
Yeah.
But you can use it. Tulalip, unless they've changed something very recently, I think they'll take checks or money orders by mail, and they'll take credit cards in person, but I don't think they don't have a portal or anything that can do that. A lot of the case management systems that are out there do have modules that allow you to do that, but I've done a ton of tribal court assessments, and one of the things that we hear over and over again from the courts is that those are all built for large systems. They're all built for a state system or a county system, unless you're as big as like Pascua. And even that tribe is, not that big, 20-some thousand, right? So most of those systems are way overkill for what a tribe needs, and also way expensive. So it's hard to get. I haven't found like a good system like that where you could do e-filing, for instance, through the system, or payments through the system, unless you go with one of these payment ones, but just accept that they're going to take 6%, which you could add on. If somebody wanted to pay online instead of coming in person, then you could, I think, probably force them to pay the 6%. I don't love that idea, but they're out there.
Yeah, I mean, we might want to consider, these types of discussions in the future, especially when we're talking about limiting exposure and limiting the folks who are coming into the court, and talking about things like being able to amend rules and policies to accept payments by mail. Of course, that's a very simple thing for most of us to do, but a lot of us deal with electronic payments pretty frequently. Some of us deal with electronic payments pretty frequently. So it might be time to start thinking about, okay, so yes, those massive systems that are built for state courts, that those are really expensive and really unruly and aren't really necessarily conducive to the work that we're doing with our tribal dockets. So what about third-party payment systems? How do we implement that? Would the court be willing to eat that 6%, or is that something, like you said, Ron, that we pass along to the individual paying the fine? That's a conversation that could be had, but then also might limit the access of those, not necessarily access, but the exposure for those people trying to come to the courts to pay those things like fines. And I only wanted to bring that up because, again, we do have a lot of courts that are currently still shut down. So when they open up, they are going to be asking these types of questions and trying to determine, what are the screening questions, what does our forms look like, and what type of access do we allow into our buildings.
And Nikki, on that same note, we're also having public defenders put on the record the difficulty that their clients are going to have after they enter a plea agreement to meet the timelines on that plea agreement. So if they have to go to 10 sessions of a MAD impact panel, or if they have to do counseling, they're basically putting on the record that, hey, my client's going to have difficulty because not only is he unemployed, no one's hiring right now, or he just lost his job, he can't pay his fines, he can't pay his court fees, and he can't attend these counseling sessions. So they're already putting on the record that although the plea agreement says X, we're going to probably be back in front of the court addressing why these things haven't happened, when you might have held the person in contempt, revoked their probation. So there's a lot of adjustments that will have to happen on the back end that the court will have to consider. And so I'm putting in my court orders, hey, here's what's going on with the pandemic, here's what we're doing for PPE, and this is how it's consistent with case law. and we have on the record the public defender saying that this client will either need extra time. Prosecutor isn't really, responding or objecting to what the court is being advised of, but it's being put on the record so that we will be dealing with this in 6 months to a year, depending on the plea that was entered by that person. So everything will be impacted in the future for sure.
Fantastic. That's some fantastic, information, Fred. Thank you. And I think it's really relevant, especially for those of our attendees. I'm absolutely seeing some defenders on here and folks who represent indigent individuals. So thank you for that. And also for those of you who are on the webinar, we're hoping to connect with Indian Legal Service folks, folks that represent individuals on a future virtual talking circle to really talk out some of these issues with you as well. So please keep an eye out for that. We'll go ahead and send out a notice a few weeks before we try to convene that virtual talking circle. But we definitely want to be able to talk a little bit about, those individuals, how they're being impacted, and really about, collaborative approaches to ensuring that the individuals who are seeking justice in our courts are still getting the assistance that they need. So thank you for that, Fred. And we are nearing the end of our webinar. So unless anybody has any, last minute questions, we do. We'll go ahead and I'll ask you this last question, and then we'll go ahead and close everything out. So what long-term plans do your respective courts have if the pandemic lasts longer than expected?
I think at Bosco Yaqui, we're being fairly cautious. We're looking at this not only either subsiding this summer and then coming back, consistent with other pandemics. We're thinking long-term. We're thinking that some of these measures are going to have to be in place for quite a while. I think everybody, litigants included, are knowing that some of these things are going to be something that are going to be integrated into our system. There's some of the things that we've been doing with other people that come into our courtroom, whether they have a contagious disease, hepatitis C, some of the things that we might not have been looking at really closely in the past is probably something we'll be looking at a little closer. People that come into our courtroom get a health screening. That sometimes is not shared with the court. It sometimes stays at the detention level. But they're coming into your courtroom, they're interacting with court staff. Sometimes they're sick. Sometimes they're going from the courtroom to a hospital or emergency room. Sometimes they're being checked by the fire department or medical staff after court hearings. I've had that happen. So it's just something that I think we probably should start to integrate it into our daily practices, PPE, gloves, where we use, perhaps detention came in with gloves, maybe court bailiffs and staff have to be thinking that at least within the next year or so.
Yeah, I agree. The jury trial is probably the biggest issue. All the courts are looking at this. One thing you might want to look at is, I haven't looked at it, but Pierce County Superior Court here in Washington State has been doing mock bench trials completely over video, and they've been posting those up so you could watch how they handle documents and do all of that stuff. I mean, I think for the non-jury trials, we can get to where we can do a lot of, if not everything, pretty remotely. I'm just not convinced that even if we had a great system for screening and PPE and big spaces and social distancing, I'm not sure you're going to get a jury pool to come for a couple of years, to tell you the truth. I mean, until they feel confident that there's a vaccine, even if you're screening out elders or people with heart conditions or things like that, I'm just not sure they're gonna show up. And then that's gonna put you in the position, are you gonna hold them in contempt for it? I don't know. I think it's rough. So I think people are gonna have to get creative on the jury trial, criminal jury trial issue, if this drags on too long. But I think we can get to where we can do almost everything else pretty remotely. It's not going to be easy. It's probably going to take twice as long, but we could do it.
One quick question as a follow-up, because we were talking about technology and that this is likely going to be our new normal for some time moving into the future. We have a question here in the chat box that says, our Zoom court hearings and social distancing has caused issues with litigants being able to confer with their clients, and complaints have been made about that. What are your thoughts on the issue?
I don't know. You have to figure out a way for the attorney to consult with their client. I mean, you have to, you know, to the point to where I don't know, they've got to have cell phones, or you're going to have a place that they could go to talk on the phone, something. But in the criminal side, you know, from the public defense point of view, if they have an attorney, you have to let them consult with their attorney in a confidential manner. So you got to get over that. I mean, I know that Zoom and things have, you know, breakout rooms and things you can do. You know, you can put in place administrative orders and things that make it a, you know, crime or a real, you know, breach of ethics for anyone to try to listen in on a breakout room between an attorney and his client, or have something to where if the moderator is a third party, some sort of statutory protection, I guess, maybe, that you could allow a moderator who's all bound up in confidentiality rules or laws to be able to listen in if you couldn't figure out a way not to. But you've got to figure out a way for clients to consult with their attorneys.
I've taken recesses. We've gone off the record, and I asked the public defenders if they've had an opportunity to speak to their client. We've rescheduled for the afternoon so they can, you know, go talk about the plea a little longer. If they were in custody and they haven't had a chance, they could usually get to them in detention. However, I'll ask them also, you know, you're appearing by telephone. Have you called your client? Have you met with your client? And they respond to the court. I've asked them to follow up with a written motion and put in writing that they've done certain things, so that I'm making sure that they've done that, so that the issue isn't raised in the future, but also that that client's rights are being protected, that they have, you know, we have contract attorneys, we have public defenders. They're off reservation. They're calling in from miles away. Sometimes a person's in custody. Sometimes a person's on the reservation in housing. And we're trying to social distance, but I think they still need to contact their client, and they still need to make sure that they're talking to them, especially if they're going to plead guilty or plead not guilty on behalf of them, and schedule things. I'm making sure that that's happening, putting it on the record, and then also asking them to submit something to the court in writing before we proceed.
Thank you, Fred. Ron, that's really helpful. And these questions are, especially since, as we've mentioned at the beginning of all of this, that this situation is really unprecedented. And, you know, this has never happened, a pandemic to this extent that has, you know, really affected not only our communities at large, but the way that we work and the way that we're administering justice in our tribal courts. And so what we're really doing is living through this situation and trying to issue spots and to share information from court to court. We don't have all the answers at this point. And what we're trying to do is identify some practices that will be helpful in the future, or helpful as we are trying to reopen our courts, or something that might be helpful to your court right now, especially if you're still out allowing access to your court for limited types of cases. But like we said, this is an ongoing issue, and we really appreciate not only your attendance and your questions, but thank you so much, Fred and Ron, for your willingness, your time, and the amazing presentations that you provided to us today. I really appreciate your voice, and also, bringing your experience to the table. We value these conversations and the ability to present this information to all of our folks, and to allow this to be replayed over and over again. So like we said, please keep an eye on our presentation schedule. Next week we will be taking a break, and we will update our schedule online, and we'll pick up in about 2 weeks, exactly 2 weeks from now, with a presentation on domestic violence. And then we will try to continue with our weekly schedule thereafter. And we will also be trying to convene some discussions regarding court openings, things like screening, and a lot of the information that we've already begun to start talking about. Not only in this particular webinar, but in the webinars that we've had in the past 6 weeks. So thank you again for your participation and for your time. Please stay safe out there. On behalf of the NAICJA Board of Directors, the NAICJA Steering Committee, and the NAICJA staff, we wish you well. Everybody, please stay safe, please stay healthy, and we hope to see you here in 2 weeks. All right, thank you, everyone. Take care.
Thank you.
Thanks.